When a shareholder dies, the impact on a company can range from mildly inconvenient to full-blown chaos, depending largely on what's been agreed in advance. Broadly speaking, there are two main scenarios to consider. First, where there are no compulsory transfer provisions in place, and second, where there are. And if you want to find out more about what compulsory transfer provisions are, make sure to watch our other video, where we explore key provisions in a shareholders agreement. Let's start with the more adventurous option. No compulsory transfer provisions in either the Articles of Association or a shareholders agreement. In this situation, the deceased shareholders' shares will usually pass to their personal representatives, so their executors or administrators, and eventually to the beneficiaries of their estate. That means the company could suddenly find itself with a new shareholder who was never part of the original plan. This could be a spouse or another family member or someone whose only prior involvement with the business was politely asking how it was going. Now, from a legal standpoint, this is perfectly valid. Shares are property, and like most property, they can be inherited, but from a business perspective, it can be less than ideal. Existing shareholders may find themselves in business with someone who has no experience, no interest, or very strong opinions formed over Sunday lunch. There's also the question of control. If the deceased held a significant stake, those shares could shift the balance of power within the company. Decisions that were once straightforward may suddenly require delicate negotiation, or at least a very good mediator. In short, without compulsory transfer provisions, you're essentially leaving the future ownership of the company up to the laws of inheritance and a bit of luck, which is not usually considered a robust corporate strategy. Now let's turn to the more organized scenario, where compulsory transfer provisions are in place. These provisions, typically found in the Articles of Association or a shareholders agreement, require that when a shareholder dies, their shares must be automatically offered for sale, usually to the remaining shareholders or sometimes to the company itself. This creates a much smoother transition. Instead of shares passing automatically to beneficiaries, the surviving shareholders have the opportunity to keep ownership within the existing group. Think of it as a pre-agreed exit plan, one that avoids unexpected arrivals at the boardroom table. Of course, this raises an obvious question. How much are the shares worth? Good agreements will include a clear valuation mechanism, whether that's a fixed formula, an independent valuer, or something in between. Because nothing says difficult conversation quite like trying to agree on price after the fact. There may also be an insurance element involved, commonly known as shareholder protection insurance, which can provide the funds needed for the remaining shareholders to buy the shares. This helps ensure that no one has to start selling their assets to make the deal happen. But that's a whole different topic for another video. Overall, compulsory transfer provisions bring certainty, continuity, and, perhaps most importantly, fewer surprises. They allow the company to retain control over who owns shares and help avoid potential disputes at an already sensitive time. So, the key takeaway is this. If nothing is in place, the shares go where the estate dictates, and the company adapts as best it can. If proper provisions are in place, the process tends to be more controlled, predictable, and far less likely to cause headaches. And when it comes to shareholder arrangements, fewer headaches is usually a very good thing. If you found this useful, make sure to hit subscribe for more straight-talking insights on company law and business ownership. No fluff, just the stuff you actually need to know. Thanks for watching.